Welcome, everyone, to Lunch with Liz, estate planning for our community. Um, I know this was supposed to happen a couple of weeks ago, and I'm sorry for the delay. I appreciate your patience. My mom passed earlier this month, so had to rearrange some things, but I do appreciate you joining us today. My name is Liz, of Lunch with Liz. An estate planning attorney. I do things with like wills and trusts and powers of attorney and living wills and things with probate and trust administration and Medicaid planning for people that are needing to go into a nursing home. My last name is Moneymaker. I promise I didn't make it up. It was my dad's name and his dad's name and multiple generations before me. And my firm is Ferrari, Butler, and Moneymaker. So if you have a Ferrari and you have a butler, then you're obviously going to need a moneymaker to make it all work. So why Lynch with Liz? I found that during my years of practice that there were just multiple occasions, actually daily occasions of misinformation. And you probably have that in your own practice area, your own profession. You just see people that, don't know really what goes on, and they rely on television shows or social media to make their decisions. And that really scared me. So I created Lunch with Liz as this virtual way to have a conversation. I'm going to do some slides today. And I do find sometimes with some of this information, doing the slides for a little bit does help. But mostly I want to be done with the slides in 20 minutes or so. And then we have opening up for questions and conversation. You can ask questions by coming off mute. You can either come on video or not. And you can also use the chat feature in the Zoom. I won't look at the chats right away, but I will get to them once we finish with the slides. Okay. All right. So thought I was sharing that. There we go. All right. So today's agenda, we're going to be talking about estate planning for our community. It's going to be talking about something that's universal, which is the need to have a holistic estate plan. It may be a complicated estate plan, it may be a simple one, but having a holistic one that fits your goals and your concerns is important. But today's focus is all from an LGBTQ perspective. Some people would say, well, it doesn't matter, it's all the same for everyone, but it's really not. For our community, we have to think about political and social challenges to our relationships and our family structures. We have to worry about our marriage not being recognized legally. So ensuring that we're putting safeguards in place to ensure that our asset transition goes the way we want it to, that we can visit each other in the hospital, that we can make medical decisions and financial decisions, and that we can retain custody of children that we might not have legal guardianship over. So that's why we're doing this Pride session on estate planning, because our community does have nuances that other communities don't. This is the documents that we're going to talk about today, and I like to divide them up into two categories. The top two are things that we think about when you're incapacitated. So you're alive, but you're in a situation that you can't make decisions for yourself. You can't make medical decisions, or you can't make financial decisions. So what can we put in place that ensures that your partner, your spouse, your best friend, whomever you've chosen, gets to make those decisions for you? And the other category is, well, what happens to my stuff when I die? And that's where we're going to talk about the last will and testament, the living trust, and other options that we have when it comes to estate planning. So you might be thinking, Liz, this sounds like a lot. What if I just keep burying my head in the sand? Well, I like to say not having a plan is a plan, but it's not a very good one. If you don't have a plan, the state of Florida has one for you. A properly written plan is your only way that you can control what happens. Because if you don't put a plan in writing, that's done correctly and legally and enforceably, then a probate judge is going to get involved, whether you're incapacitated or you've passed away. The state of Florida law is going to dictate everything, who's in charge, who gets what, and what they get. You don't have any control over your body if you're alive, or your assets if you're dead. And most likely, your biological family is either in charge or involved, even if you didn't want them to be. Planning is critical for us because a lot of times we have chosen beneficiaries or chosen agents and decision makers that aren't our biological family. So ensuring that your documents are in place that have clearly indicated what your wishes are is why that planning is critical. Because once it's too late, it's too late. Once you're in a car accident and you can't do this anymore, it's too late. Once you had a stroke or diagnosed with Alzheimer's, it's too late. That's why proactive planning is critical. Planning for incapacity. So first part about planning for incapacity, I remember this is where you're alive, but you can't make decisions for yourself. The first document I want to talk about is the durable power of attorney for finances. And look, there are a lot of powers of attorney out there, a lot of different types. This is why I strongly urge you to not just go pull something off the internet. It's important for estate planning purposes that you have a durable power of attorney that complies with the durable power of attorney statute, and that includes the powers that your loved ones will need to protect your assets, to apply for Medicaid if they need to do the things that they might need to do to safeguard your wishes. And the reason why the durable part is important is because if your power of attorney isn't durable, it becomes ineffective upon incapacitation, which is the whole point of this particular power of attorney that I'm talking about. You want it to be in effect when you are incapacitated, because that's the whole point of giving your chosen agents this authority. Because now you can't. You're at your most vulnerable and you cannot make these decisions. So you want to make sure that that document is solid and will stay in effect upon incapacitation. Once you have the document, your agents are able to step into your shoes financially and do the many things I've listed there, including asset protection and planning for long-term care, should you need that in the future. The next document that you're looking at for planning for incapacity is a medical directives. And there's a lot of phraseology out there. So let's just make sure we see the whole umbrella. Advanced directives, medical directives, living will, healthcare surrogate designations. Those are all under the umbrella of these advanced directives. The living will is something that helps you essentially talk from your incapacitation and let your loved ones know, do you want to be kept alive artificially? What type of care do you want if you have dementia? How do you want your life prolonged, if at all? What kind of pain medication do you want to be under? The healthcare surrogate designation is you naming someone. Sometimes it's called a medical power of attorney, but it's that person that you are going to have make decisions for you if you can't, and that person you're entrusting to carry out your living will wishes. Living will wishes, say that 3 times fast, as well. I've written there, choose your agent carefully. And I know I wrote it on the slide prior and I didn't discuss it, but it's important that you obviously have someone that you trust in this capacity. These are big jobs that can be abused if you choose the wrong person. And I have a lot of people in our community who come to me without someone to name. And there are solutions for that. There are professional fiduciaries that can step in and help, that are compassionate and caring and will step in if need be. So if you're putting off estate planning or putting off having a conversation with someone like me because of that, I would suggest don't, because there are other options that we can do for sure. And I did see that question pop up in the chat just now, so I'm gonna address it real quick. There's a question about the power of attorney and whether you can have multiple agents. You can have multiple agents if they're one, and then you have a backup and then a backup. We strongly encourage people not to put powers of attorney. So two people working in conjunction, because what we find is there are financial institutions and governmental institutions that simply won't recognize the co-powers of the power of attorney. Additionally, you have logistical issues when you're requiring two signatures and two decision makers. So that's something I talk to clients about very thoroughly. Different functions, real estate versus healthcare. You can definitely have a different agent for the power of attorney than you have for your medical directives. And often people do. They have, for example, a child who's really good at money, and that's the power of attorney. And they have a child who's a nurse, and she's the healthcare surrogate. So you can definitely have two different people for that capacity for sure. Yeah, welcome. All right, so now we are moving on to the next slide. So I mentioned earlier guardianship, and this is one of the biggest reasons why you want to have your incapacity documents in place so that your family or your friends, your loved ones don't have to pay a lawyer, go to court, have a legal proceeding to declare you legally incompetent or incapacitated, and then have somebody, whether it's your loved one or not, take over your affairs and make decisions for you. Give you a quick example. I had a case a couple of years ago. I don't do guardianships anymore, but I did a few years ago. And I had a client who he and his partner had been together about 20 years, not married. Partner had dementia, and he needed to get guardianship over his partner because there were no documents in place, unfortunately. Well, the partner's family, who was estranged, didn't live in the state, had not visited the partner for over 15 years or more, co-petitioned to become guardian of the partner. We had a 3-day hearing in Sarasota about it, and the judge ultimately decided that the guardianship was best with the family. And that was heartbreaking for the partner, the loved ones in the community that had testified as to their relationship and the wishes of the person with dementia. It's unfortunate that that was never put in writing. So that's a warning to you, if I can give you one, is these are the most simplest documents to put together compared to what they save you from, for sure. And I know we have some questions in the chat, and I'll come back to those in a little bit for sure. I want to pivot now, though, from the incapacity planning then to planning for death. And I have a lot of clients that will come see me, and one of my initial questions always is, what's your concern? What's your goal? And a lot of them, their concern, their goal is Florida probate, and they want to avoid it. So let's talk about what it is before we talk about how to avoid it, or if we should avoid it. Essentially, Florida probate is a court case. It is when a judge oversees when somebody dies and they own stuff, right? They have a checking account, they have a savings account, they have a car, maybe they have some investment accounts, and they own a house. Well, if they didn't have any estate planning documents, or they relied on a will to transfer ownership of those assets, then it's going to have to be probated, and a judge is going to oversee the distribution of those assets, ensuring all the debts are paid, that all the creditor claims are dealt with, and that the beneficiaries are paid. It involves the judge determining whether the will is valid. If you don't have a will, who your actual heirs are. And Florida has a whole chart to determine who your heirs are. If you haven't made other provisions in writing. In the court process consolidates all your assets. So maybe sells your house, maybe, liquidates all of your accounts, pays your debts, pays your taxes and expenses. And then in the end, usually 9 to 12 months later, um, anything that's left is distributed to your heirs. Okay. So that's Florida probate. So now we're going to talk about planning for death and whether avoiding probate is something that you can do. So first, let's talk about a last will and testament. So this is a legal document that if you're relying on it to transfer assets, then the judge will accept it into probate and then determine how your assets are distributed. You have named a personal representative. It's also called an executor in the document, and that person is in charge of collecting all your assets, paying all your debts, paying all your expenses, and then distributing the assets to the beneficiaries. We're going to talk about this in a little bit more, but when I say if you are relying on a will to pass your assets, it will need to go through probate. That phrase is not the same thing as if I have a will, my things have to go through probate, because there are other ways that we can set up your estate so that the will doesn't require a probate. Okay, we're going to talk about that. So I think I saw a chat question pop up about pay on death or transfer on death. We're going to definitely get to that. All right, so that's what a will is. Let's talk about what a trust is. I like to think of a trust like a bucket. So it is this separate entity. So let's say Liz owns a condo. Liz owns a couple bank accounts. Liz owns a vacation home in North Carolina. I don't. I wish I did. But for this, let's say I do. And maybe a timeshare, right? So instead of Liz owning it, I draft a bucket and create a bucket. And I put the timeshare in the bucket. I put the house in North Carolina in the bucket. I put the condo in St. Pete in the bucket. I put my bank accounts in it. So now, instead of Liz owning all those things, Liz's bucket owns all those things. And I put instructions. That's what I write as a lawyer, the instructions on the trust as to what happens to what's in that trust after I die. It might be that it all goes to charity. It might be that I set up a fund for my nephews so that they get distributions every year for 10 years. The great thing about a trust is you can use it to control from the grave and to avoid probate if you have assets that you can't avoid probate any other way. And that's part of the process of my consultations with people, is identifying the assets and what are the ways that we can distribute those at death that avoids probate. Sometimes a trust is the only way, but I would tell you, I have a lot of people come in my office and their brother has a trust, or their pastor has a trust, or their, neighbor 3 doors down has a trust, and they think that they need one. And when we walk through all their assets and their goals and their concerns, turns out there's an easier way. And that's highlighted below on this slide. Is my real focus is what's the least complicated, most cost-effective way to accomplish it. If you need a trust to accomplish your goals, then you just need it. You need that more complex estate plan. But if you don't, if we can get you there in a Prius versus a Bentley, then I'm going to recommend the Prius. It's always the client's decision which way to go, but we want to make sure that they have those options available to them and they understand all the price points involved. These issues here on this slide, no matter who you go to for your estate planning, these are the things that you want to be talking to your attorney about, because these are the things that dictate which tool is going to be best for you to accomplish your goals. The category there about special needs beneficiaries, I put, for example, if they're on public benefits, like Medicaid or something like that, SSI. But additionally, I have clients whose beneficiaries have drug problems, alcohol problems, or gambling problems. So in those cases, this is where a trust probably would be the best option, because we could control from the grave on any types of distributions. Let's talk then now about, okay, Liz, I'm coming to you and I want the least expensive, most cost-effective way to accomplish my goal. So these are some of the other options that we're going to talk about. One is joint ownership. This could be where you put someone else's name on a deed, so on real estate, or you add someone's name to a bank account. I put a big red flag there, and the big careful with this and discuss with an attorney slash CPA, because I've seen this really bite people in the derriere if they're not careful. For home ownership, for example, just adding someone to the deed can have gifting issues, can have homestead issues, can have what else can they have? Tax issues upon sale or reassessment of the house. So you're going to be very careful with doing that. It can also have issues with Medicaid planning if a parent puts a child on the house as well. So these are just things. I'm not saying it's 100% don't do. I'm saying always, my suggestion is always to talk to a lawyer and or a CPA about those ramifications before you do it. When it comes to bank accounts, I've seen clients put children on their bank accounts because they think, oh, that'll be easy. Well, then the one issue is the parent dies, and then now this money belongs to Joe, but Joe also had three sisters, and it was Joe's mom intent that Joe share all that with the sisters. But you know what? Legally, that's Joe's money, and now he doesn't have to. Another issue with adding children or anyone onto a joint account is legally they're entitled to that money. So they could go in and clean it out. If they get into an automobile accident or declare bankruptcy, that money in that account is theirs legally and can be a liability and be taken from the real owner of the account. Again, I'm not saying not to do it. I'm just saying it's something that you want to be careful about, and you probably want to get some legal advice prior to doing so. Some other ways that we avoid probate are things like pay on death and transfer on death designations. Pay on death designations would be on things like money market accounts, checking accounts, savings accounts. These are forms that you fill out at the bank. A lot of times you do it and you've forgotten that you did it because you did it when you set up the account. But some people don't. So it's worth checking to see if that's something that you already have on your account. Transfer on death designations is the same concept. It just is a different type of account, like a brokerage account or a certificate of deposit. Those would say transfer on death versus pay on death. And similarly, beneficiary designations avoid probate. So things like your IRAs, your 401ks, your life insurance policies, those all have the ability to have beneficiary designations. So when you have beneficiaries on those, it doesn't matter what your will says, doesn't matter if you have a trust, that if they're not in the trust, then it's the beneficiary form or the transfer on death or pay on death that dictates, and that avoids the probate process. Lastly, what we can do in Florida is for real estate, things like condos and houses, for example, we can do what's called an enhanced life estate deed. The slang for it, for some reason, is ladybird deed. This is essentially where you can put a beneficiary on the deed. So let's say, again, Liz has that condo, right? So I do a new deed and it says, I'm deeding this condo to myself for life. And then when I die, I want it to then go to whomever. There are some negatives, some things that we can't do with a ladybird deed. So again, this is just part of the conversation that I would have with a client about the pros and cons, what you can and can't do. Can't control from the grave with a ladybird deed. You can't plan as much for contingencies with a ladybird deed, but it is an excellent tool to avoid probate, especially if someone's nearing the need for nursing home. And wants to get on Medicaid, we can do the ladybird deed, passes automatically at death and avoids probate, so avoids any Medicaid clawback for anything that Medicaid had paid for the nursing home. So it's a great tool. Not great for everyone, not great for every occasion, but it's certainly something that I would most likely talk to a client about. I'm almost done with this, and then I'm going to get out of the slides and I'm going to go to your questions and we can start our conversation. But I just want to go with this quick example. So for this one, let's assume John is unmarried, but it really doesn't matter, really. Let's say he owns a house, he has a checking and savings account, a brokerage account, he's got a retirement account and life insurance. So he says, Liz, I want the simplest, most cost-effective way to do this. I don't need to control from the grave. My beneficiaries can get everything out right. Remember that slide that I talk about caveats and cautions? Let's say we walk through all those. He doesn't have any of them. So the simplest way that he can avoid probate is a ladybird deed for the house, making sure he has his pay on death, transfer on death, and beneficiary designations intact. Now, is he going to need to keep up with those throughout life in case he changes his mind, in case a beneficiary dies or something like that? Yeah, this is not a set it and forget it type of plan, but it is your most least expensive in the simplest way to go about avoiding probate. I'm going to stop sharing now, and I'm going to go to the chat and see what I missed. All right. So if you have other questions, you can throw them in, or if you want to come off mute, we can do it that way too. Question. I have friends I want to leave money to. Two of them have adult children. If they died before me and I had not changed my will or trust, would their children get my gift? That's going to depend on the language of your document. For example, it could say in your document that if a beneficiary dies, it goes to their children. That's often called per stirpes, if you see that phrase in your documents. Or it could say it goes to the survivor, or it could say it goes to somebody completely different. There's no rules there. It just depends on how yours is set up. Next question, Tony. Payable on death is not sufficient for my partner to get my money. It's sufficient. I think I understand the question. If you have your partner as a pay on death beneficiary on a bank account, a savings account, something like that, that is sufficient for your partner to get that money. I mean, that's a simple, I don't know your big picture or what money you're talking about, but a pay on death designation is a simple way to do it. And then I got a question, do I cover Orlando? I covered the whole state for estate planning, probate, and all of that. The only issue with people that aren't in the Tampa Bay area is the signing, because we don't do DocuSign. So you have a couple options. The best option is you take a field trip to St. Pete, and I make sure that your documents are signed and everything's perfect. A lot of my clients don't want to do that for some reason, even though St. Pete is lovely. So we provide them with the documents, we provide them with signing instructions, and we refer them to a mobile notary. And then they do the signing on their own. Your other option is, I can help you find someone in your area that I know and trust as well. All right, next question. Can you leave money and assets in the USA to non-US beneficiary living in Italy, for example? Absolutely, you can. Keep in mind that countries have their own laws when it comes to taxing inheritances. So, and I don't practice in Italy, but I know that I have some cases in France and I have some cases in England where they tax the inheritance. So, that's something you'd want to talk to your attorney about to see if there's some other ways to provide for the person to potentially avoid that, or at least make sure that that person is aware that they're going to have to pay taxes.
Because, can I ask you something? Hi, Liz, Massimo, and obviously I'm the one that wrote that question.
Yeah.
Because many times, like in the bank accounts, like you were saying, there is somebody where you can say transfer on death or pay on death type of situation. But when I want to put like my sister in Italy, for example, as a beneficiary, she doesn't have a social security number, and so that kind of gives me that question of how does she get to that money, not having a social security or something?
Oh, I see what you're saying. So yeah, on the pay on death designation, you might not be able to do it that way, but you certainly can do it via a will or a
A will,
trust.
right? Okay.
Yeah.
Thank you.
Yeah. And then Tony, you have I'm not sure the question, even with right of survivorship on a deed. If you want to come off and talk to me or give me clarification as to that question, I'll come back to it. Amy, are there also tax advantages to trust over other options? There can be if you are of the, right now the estate tax threshold for an individual is like 13 something million. I don't know the odds and end number off the top of my head. Almost 14 million actually. And then for a married couple, it's 28 million something. So, and Florida doesn't have a state tax. So I always put language in my trust to plan for when that threshold isn't so high. It certainly has been as low as 75,000. It's been a few years since that happened, but every administration threatens to lower the threshold because the higher it is, right, the less money is going to the federal government. So we always need to put language in there. So that's my long answer. There are tax advantages, Amy, if you need the tax advantages over a trust. If you don't have a taxable estate, there's not tax advantages per se, but you are not then having the probate expenses. To probate something, your executor is going to have to hire a lawyer, pay court costs, pay attorney's fees, pay the other expenses of the probate. So usually when I do the math for people, if they need a trust to avoid probate, and again, they might not, but if they did, it's much less expensive, even though a trust-based plan is the most expensive plan. It's less expensive than probate would be down the line. All right, next question. Great segue, Anthony. Thank you. What are some of the costs in general associated with a probate case? I think I just hit that, but let me talk about some of the court costs. You've got the filing fee, which is over $400. You'll need to put an ad in the legal paper about the death, and that's usually 100 some odd dollars. The judge is going to require you to post bond, and that's going to depend on how much the estate is worth as to how much money that is. Then there's certified copies, there's FedEx requirements, there's notifying all of the creditors if there are any, it's notifying all the beneficiaries. So you have mail costs, certified mail costs. So I generally tell people like you're looking at under 1,000, but oftentimes it can be 1,000 and just hard costs as to what it costs to actually file the case. Next question. Do you have to be divorced to change your will and beneficiaries? Do you have to be divorced? No, a will you can change. You can change every month if you want to. I have a couple clients that are frequent flyers. They change their mind every couple of months or every 6 months. That's the nice thing about estate planning is that you're in complete control over it, and you can change it as much as you want. You don't have to be divorced. If the question was, if you got divorced, should you change your will and beneficiaries? Then I would say probably, maybe it was an amicable divorce and you want to keep everything the same. But generally, I find that when people get divorced, they want to update who their agents are and update who their beneficiaries are. Next question. These are great questions, by the way. Keep them coming. If we do a will in Florida and then we move to another state or even another country, is that enforceable? So in another state, yes. So you do your will in Florida and then you move to New York, for example. Mm-hmm. The full faith and credit clause of the Constitution requires that New York will recognize your will if it was done in accordance with Florida law, which is if you take the field trip to St. Pete and I oversee your signing and everything, it's going to be done in accordance with state law. So state laws, other states have to recognize it. That being said, quick caveat, I always tell my clients who are moving, go see an estate attorney where you're going, because there could be laws, especially for our community. If you're moving to a blue state, you could have laws that you want to make sure are embedded in your documents because they're a better protection for you, whether it's financially or your marriage or something like that. So good practice is just go see someone. You might not have to update, but you at least then you have the knowledge of whether you should or not. The Moving to another country is a little bit more complicated. When you're moving to another country, which I got to admit, I have a lot of clients in the last 6 months that that's their plan or they've already done it. The documents we would create for you here would still control your US based assets, right? But if you purchased assets in the other country, you purchased a home, or you have
Mhm.
a bank account in that other country, that country's laws would dictate. So you would need to see an attorney or notary, whatever they call it in that country. And then we just want to make sure that the two plans don't contradict each other.
Okay. Thank you.
Okay. You're welcome. All right. Next question. What are my fees to edit an existing last will and testament? I don't edit documents I didn't create. So I have a zero fee because I don't do that. I do offer complimentary consultations to talk about your goals and how we can get where we want to be. And I have, pretty set packages when it comes to things I recommend, and they're flat fee and no hidden costs. But I don't edit other documents. I will review documents. Like, let's say there's a client moving in from Ohio. I'll review those documents for legal sufficiency here for a fee. I don't do that complimentary. But I do meet with you to discuss your estate plan complimentary. Um, okay. Next question. Mine should be one of the simple ones to create. Famous last words, DJ. Yeah. Everyone thinks they're simple. Please share what to expect about your fees. I do have friends in St. Pete. Um, I'll give you just a basic, like if it's a single person and you're coming in and you're wanting to create a will, power of attorney, and healthcare documents, I do that for 750. That's includes the complimentary consultation, going through, the holistic idea of where you are, what your goals are. And if that's where you ultimately want to end up, then that's my lowest level package that I offer. Um, Next question. Can a person do a will or trust with their spouse or significant other when all assets are jointly owned? Um, with the spouse, yes. With a significant other, no. And that's something that I talk to clients about if they're leaning towards a trust, about the benefits of a joint trust versus separate trusts. I have clients that go both ways. Depends on the commingling of the assets, depends on whether they anticipate inheriting assets from other people that they don't want to commingle. Depends on whether there's children. That's why we have a consultation so that we can go through all of these aspects and figure that out. Let's see, what kind of taxes would I have to pay after receiving money from a trust from a parent? Don, that would depend on what you're receiving. So if you're receiving just a lump sum distribution from a brokerage account, then there's no taxes on that. But if you're receiving, and I should caveat this with, I'm not a tax professional, and I always tell people to go see their tax professional. But one of the things you do pay taxes on is if you inherit like an IRA. And then when you take those distributions, then that's income to you. So you're just adding it to your income. Um, and I think I'm at the end of the current questions. Any other questions or
Yes,
want me to
Liz.
circle back? Yeah, Tony.
Hi, it's Tony. I want to go back to the right of survivorship
Yeah.
question. So my partner and I own our home. We're both on the deed with right of survivorship as the verbiage on the deed. Is that sufficient enough that he gets the house if I die, or do we need to have the trust as well?
Great. Hello.
I'm here. Can you hear me?
I can hear you. So you guys have right of survivorship. And then was there a
Right.
question?
Yeah, do we need to have the deed as well, or is that sufficient so that he gets the home?
So your deed is the deed. So joint ownership with rights of survivorship is an excellent way for partners to own their property, because when one of you passes, it automatically becomes the property of the surviving person.
Okay, so if both of us pass together, say in an accident or whatever, I guess the home would go to who's ever designated in the will. Or do we need a trust for that?
So either one would pass the property. It just depends on what your goals are. So if you're using the will to pass the property, then it would go through the probate process.
Probate. Okay.
Yeah. If you
So the
have,
better option is the trust then, if we both pass away.
yeah, your other option is to keep you owning the home as joint tenants with rights of survivorship, but then you add that ladybird deed language to a new deed. So when the last of you passes, it automatically goes to someone. Not
Gotcha.
saying that's an option for you, but that is an
An option.
option that
Okay.
could work. Yeah.
I got you. Thanks so much.
Yeah, you're welcome. You're welcome.
I have another question, Liz,
Yeah,
if you
yeah.
don't mind.
No, you mind.
So how does it work? Like you have two, three different beneficiaries. Do you have to tell them, hey, you are on my Janine, you're on my will. Tony, you're on my will. And if I die, you call Liz Moneymaker. How does that work? I don't know. You see in movies like you get the letter and everybody goes to see what their uncle left them. Tell me about that.
That rarely happens anymore for sure. So um this is also a conversation I have with clients is do you tell beneficiaries? My philosophy is no, because what if you change your mind?
Exactly.
Because that could happen. Generally speaking, I just suggest you tell people that you do have an estate plan and where you keep it. You know, do you keep it on a shelf? Do you keep it in your firebox? Do you keep it in your safe? You know, make it clear who your attorney is, and then I would suggest you tell whoever your executor is, because hopefully you've had a conversation with that person about that role so that they know who to come see if something happens to you. And then at that point, your beneficiaries would get noticed.
Okay.
Yeah.
Thank you.
Yeah.
Can I
I mean,
ask you a question about that? Oh, sorry.
yeah, just real quick, Tony. If you did want the big reading like you see in the movies, you could put those parameters in your will. I mean, that could be like your last way to go out with a bang. But
That'd be the only way to do it.
yeah, yeah. Go ahead, Tony.
My so the question about that is no, I lost it. I'm sorry.
It'll come back to you. So just
Yeah,
holler
one
when it
thing.
does.
Sorry.
Yeah, no worries. I'm going to go to the next question. If your home is not paid off, what impact does the mortgage company have on the home with the will/trust? Do they take possession, or do the beneficiaries have to sell, pay off, or take over the mortgage? That's a great question, Jeffrey. And that's one of the consternations beneficiaries have, especially if you're using a will, and that means the probate process to transfer title of a house. So typically, when someone passes with a mortgage, we notify the mortgage company and they understand that there's a probate process that happens. So the beneficiaries, the estate either has money to keep paying the mortgage, or the beneficiaries have to start paying the mortgage to keep it from going into arrears. And then at the sale of the home, then we can reimburse the beneficiary who paid the mortgage. What if they want to keep the house though? Then they're going to have to refinance it or assume the mortgage. So they can't just take that mortgage over without, requalifying and getting the mortgage. And I'm no mortgage expert either, but that's how I've seen it happen with my clients through the probate process. If I didn't answer your question on that, let me know. But it's usually one of the reasons why we like the ladybird deed or a trust, because we can get that transfer a lot faster and get over into the beneficiary's name so that they can get it refinanced or get it sold quicker. Yvonne's giving me some law school questions. She's making me go back a few years. If partners died in a car accident, but one died minutes before the other, wouldn't the latter inherit the house and the will, or the and bottom line, Levon, that's going to depend again on your trust language or your will language. There's going to be language in there that says how long someone has to survive, or if it's the case of you and your partner, is there a presumption of who died first? Or do you presume to both die at the same time? So then your assets are split 50-50. there's a myriad of ways that your document could have language about that. So I don't know what yours said, but there's not just one answer to that question. It's going to depend on what the document itself says. Um, I've given you a lot of lawyer answers today. Well, it depends. Um, any other questions? I know we've got about 10 minutes left. If you didn't see Vicky's comment, we do post this. We put this on our website as well as on our Facebook page. It generally takes us, I think, a day or two, sometimes three, to have all those mechanisms in place. But usually by Monday after this call, we have something in place. Are there things that should be done to protect financial assets of a couple should someone be looking unexpectedly end up needing specialized care, nursing, etc.? Yeah, so that's Medicaid planning or asset protection planning. Um, there are attorneys, myself included, that do that type of consultation, that kind of advice. I can't really give you, hey, this is what should be done. It's just going to depend on what your assets are. Generally, what I tell people is don't do stuff without talking to somebody who knows what they're talking about. Because there's a lot of misinformation when it comes like, well, Medicaid's going to take your house, and Medicaid's going to take your money. Medicaid's not going to take anything. Medicaid's just not going to pay for it if you don't comply with their rules. So people can get into a lot of trouble trying to DIY long-term care planning. Gifting is a problem. Selling things for less than fair market value is a problem. So if you are thinking you want to talk to someone or thinking you might need to plan for long-term care, you definitely should go talk to someone that does elder law or Medicaid planning. Next question. Got one question, Vicki. What is the website? Would you put that in the chat? Next question. What kind of documents do you need to bring to your first consultation, or will tell you what to bring at the next meeting? Your checkbook for sure. Just kidding. Just kidding. No, we give you a worksheet before you come. So you're going to come. If you do an in-person, you can bring it with you. If you do a Zoom like this, I have to have the intake before. I've just done this too long, and the Zoom sessions just aren't as good if I don't have that ahead of time and we can't walk through it together. But what I always tell people about the worksheet is there's going to be stuff in there that you're not sure of. This is just to get your juices flowing so that when we sit down, I have an idea of where you're coming from, you have an idea of what I need from you, and then we can go from there. Let's see. Next. All right. I'll hang out if you have been too shy to ask questions in front of all our brothers and sisters. I'll hang on for a bit. Otherwise, I want to thank you so much for the great questions and showing up today. Hope you have a great Pride. If you're going out this weekend, be safe and celebrate love. Thanks, everybody.